Are you Matthew Aldridge?
I'm the attorney of fact for Matthew Aldridge.
You were what?
The attorney of fact.
Attorney what?
Of fact.
Attorney of fact. And what does that mean?
You know, right. His authorization to do legal representation.
Are you a licensed attorney?
No, I'm simply an attorney of fact.
Okay. And does that mean you have a power of attorney? What is your name? What is your name?
My name?
Yes, sir.
I don't have.
You don't have a name? Pardon?
I'm the attorney of fact for the respondent in the area.
Well, let me explain to you. Show it to the bailiff and he'll show it to me. Apparently there's a copy here. All right. This is in the state of Tennessee of Cheatham County and Chancery Court, which is filed in the wrong county because in the wrong court, because this is circuit court. You just be quiet.
You go to the court, it comes up.
You need to listen to me instead of talking, okay? This is a challenge to the standing. The Supreme Court of the United States has stated that no corporation has standing anything to man. And then there's a quotation for Rundle versus Delaware Raritan Canal Company. And then it said, as well as it being a maximum of law, citing certain Latin phrases, dissimilar things ought not to be joined by a definition of Black's Law Dictionary. So the respondent in error requires that the state of Tennessee Incorporated and Cheatham County Chancery Court prove their standing to proceed against a man in any court of law. You have 15 calendar days to prove your standing or forever yield to estoppel, waiver, and fraud, and cease and desist this proceeding immediately. More time is available if requested. And then this was signed by Matthew O'Neill Aldridge. Is that your signature?
That's the respondent in error signature.
All right. Well, I find that Matthew Neil Aldridge has failed to appear personally in this court for the plea day on his case, which was set for trial tomorrow. And as a result, you have no standing, sir, under what I know what you're trying to do is to try to use the sovereign citizen approach to this situation. And I'm simply telling you that you do not have the right to represent Matthew Neil Aldridge. If you are, in fact, Matthew Neil Aldridge, then you need to say so and stop this nonsense, because what you're attempting to do has no legal effect. You cannot challenge the criminal law or the jurisdiction of this court by simply filing some legal mumbo jumbo having to do with civil litigation. That has civil litigation in it. It is not a criminal case that you have cited. So it has no effect on this court regarding the criminal statutes of this court. This court is empowered under the Constitution of the United States of America and the Constitution of the state of Tennessee, and by the duly elected citizens of Cheatham County to empower and enforce the laws of the state of Tennessee. And that is what I'm going to go forward because of the fact that I have a conflict and I have to be in Stewart County on a civil matter. So we're going to assign a new trial date for Matthew Lynn Aldridge. We're going to need to set a trial date in July. All right. To Matthew Aldridge and the individual standing before me whose name must not be uttered, then we will set a July 15th trial date for Mr. Aldridge. Whatever this document is that you have filed is in fact invalid because it does not cite any valid criminal statute, and therefore I'm denying whatever that might be in the way of a motion. The trial date will be July 15th. The last day for Mr. Aldridge to enter a plea or go to trial will be July the 8th. July the 8th. Now, we're going to give you a card. If you are in fact Matthew Aldridge and you're just playing games with the court regarding this nonsense that you filed, then you may get this card and you may go on about your business. If you are not Matthew Aldridge, then I would suggest to you, you relay to Mr. Aldridge that he must appear on July the 8th, or a bond revocation will take place, and his case will be set, will take place with him in jail, incarcerated on the 15th. That's the judgment of the court. You need to take your piece of paper and go on about your business.
All right, 23-415-0 is called the State of Texas versus Parady. That's you, Mr. Sir. And you're here with Mr. Adams, your attorney, and the state's attorney. Does the defendant waive a formal reading of the indictment and arraignment here? Can we proceed in summary?
Yes, sir.
In summary, this indictment alleges that September 3rd, 2020, in Jefferson County, Texas, you committed the second-degree felony of indecency with a child. Do you understand what you were charged with?
Yes, sir.
If convicted, you face a term of not more than 20 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand? A numerical, and I can't read
We don't get the
that you placed in that box. You would be placed in deferred or unadjudicated probation, fined $1,000, up to 10 years on probation. And there would be terms and conditions of probation, which are normal and customary. And there would be registration requirements under the sexual laws of the state of Texas that you must perform. Is that your understanding of the agreement?
Yes, sir.
If I follow this agreement, you have no right of appeal. Do you understand?
Yes, sir.
How do you plead to this? Guilty or not guilty?
Guilty.
Sir,
Guilty.
are you pleading guilty voluntarily? That is on your own free will and because you are guilty?
That's some stuff.
Are you pleading guilty on your own free will? Nobody forced you.
Yes.
You're pleading because you are guilty of what this alleges you did in the indictment.
No.
You didn't do this.
You did do
Yeah.
right.
Yeah. Yes, sir.
What's your final answer?
Yes.
Yes. Okay.
That's not my opinion, but it's up to you, Your Honor, what you say.
Okay. I think a post-sentence report is important because I want to know what the focus is. But I think that the general terms of probation that are normal and customary for this will be applicable. But if there are specific needs that need to be addressed, we can pick those up in a post-sentence report. Okay.
Yes, Your Honor.
Okay. State okay?
Yep.
All right. That's what we'll do. Do you understand the situation here?
Yes.
Intelligently and because you are guilty. All right. Anything else to add? I'm going to follow this agreement. You need a pen?
Yeah, I was right. Yeah, look. Hey, I'll take it.
If nothing further, I'm going to find you are pleading guilty today to the second-degree felony of indecency with find you guilty beyond a reasonable doubt. But I'm going to defer any finding of guilt and place you on deferred or unadjudicated probation for 10 years. There will be terms and conditions of probation, which are normal and customary for this type of offense. Also, we will come back after the post-sentence report is made so that we can review this report, all parties, and if there are any additions or changes that need to be made based upon the findings from the probation office, that will have to be included because we want to prevent or deter any further misconduct. Anything?
I just wanted to make sure we're putting him on probation today, but doing what would amount to a pre-sentence report.
Yeah, we'll call it a post-sentence because he's been sentenced today. But it would work just like a pre-sentence report if there's something that we need.
Okay. Understood. That's what's the agree on.
How long have you been in jail now?
In January 30th.
Of this year?
Yes, sir.
It's about 6 months, 5 months.
Yes, sir.
How's that working out for you? Yeah, I wouldn't be happy with it. You're not enjoying yourself.
No, sir.
Can you imagine what 20 years in prison would be like? Are you focused now?
Yes, sir.